The time is 5 o'clock.
Do you have an unresolved problem and you're finding it hard to fix? Do you have pending issues in court and you're tired of adjournment? Is it land issues, investment issues, inheritance issues, family issues, loan repayment issues, or broken agreement? Do you want to settle out of court? Then join Gabriel Onovo every Tuesday by 5 p.m. on Mediation Matters. This is Mediation Matters with Gabriel Onovo.
Okay.
People will listen to you very well and obey what you are saying. Definitely, no one will go to court.
Hey, Gary.
Next I call, thank GO and associate.
Thank you.
And they do well. This information is very good.
Thank you.
Is there any financial commitment?
If you say you no get money, we go do am free for you. Now, e dey private, confidentiality. That for ADR, everybody go win. We handle your dispute professionally and peacefully. This our mediation. No be only us dey do am o. We dey collaborate with experts. We dey work with even the multi-door courthouse for Kaduna State Judiciary. We dey work with National Human Rights Commission. Wow. E don clear say court no be the only way to settle matters. Alternative dispute resolution dey save time, e dey save money, and e dey preserve relationship with you. Join us again next week for another correct edition of Mediation Matters with Gabriel. Make una remember,
Welcome to another impactful edition of Mediation Matters. I am your host, Gabriel Onovo, a chartered mediator, a conflictologist, and a peace consultant. Lead consultant at GO and Associate ADR Hub. Today, we are tackling a vital topic for lawyers, law students, and the public alike. And the ADR legal profession, why every lawyer needs mediation in their toolkit. This conversation is about transforming how we solve disputes, moving from confrontation to collaboration. Joining me today is a legal expert, someone who is passionate about alternative dispute resolution, a trainer, a barrister, Nanchang Nangwang Mishti. He's making great strides in both the legal and mediation space. Barrister, you're welcome to the show.
Thank you very much. Thank you.
All right, sir. Like is our norm, let's throw a little preamble on what alternative dispute resolution is all about. And let me carry our pidgin brothers along. Now, Mediation Matters we dey talk today. And my name na Gabriel Onovo. Like we dey always talk and say, mediation na wetin everybody needs to put hand inside. Wetin be this mediation wey we dey talk? Na alternative dispute resolution. And like we dey talk am before, we say alternative dispute resolution na one of the options for the courthouse. You see, like we talk am before, we say for courthouse, no be only litigation na him dem dey take solve problem o, my people. We get mediation, we get arbitration, we get conciliation, we get negotiation, and we get litigation. So why everybody go just go sit down tanda for litigation? We say when you explore these other options, you go still get solution for this your problem. Wetin be mediation? We say mediation na a process where a neutral third party go come into your problem with your brother. He go hear una story and he go help una, he go guide una, make una find una own solution to una problem. Now that's one we dey call mediation. We can't get conciliation. We say this conciliation, like I dey always talk am for here, I dey say conciliation na the elder brother of mediation. Why? Because conciliation na a process where another neutral third party, he go come hear una problem between Mr. A and Mr. B. In this process now, the conciliator now go come advise una, say this una problem o, see how una for take solve am. Then una go come solve am. Na him be conciliation. Now wetin be the difference between this mediation and conciliation? You go observe say for this conciliation, the conciliator go fit advise, while in mediation the mediator go only guide una make una solve una problem. Then we come get negotiation. Wetin be negotiation? We say na like when you get business transaction with somebody, I think come kasala. you can't need a professional negotiator make e come help you, guide you on how you go take negotiate so that you go fit get something when better there as the outcome. Na him the person we dey call negotiator. We can't get wetin we dey call arbitration. Like I dey always talk, na like the elder brother or the younger brother of litigation, because for arbitration you go get wetin wey we dey call arbitrator, a neutral judge wey sit down like judge for courthouse. You go come hear the matter between Mr. A, you go hear the matter between Mr. B, you go come give wetin we dey call an award. You go say as this matter be, see the person wey suppose get right for this thing. And this thing, the good thing about this ADR be say e dey fast, e no dey cost money like that, and e dey preserve relationship. So my people, na him be a short version of wetin ADR be all about. So now let's go back to our program in a proper context, so to speak. We have this evening we have a barrister with us. So sir, can you let's hear from you. What led you into ADR, and just give us a background of what you do, sir.
Well, thank you very much. My name is Nanchang Nangwang. I am a lawyer by training and an alternative dispute resolution expert. I practice in all the spheres of ADR, including negotiation, mediation, arbitration, among others. I am privileged to serve as the executive director of Settlement House ADR Training Institute, an institution for the training and certification of mediators, arbitrators, and negotiation in Nigeria and the world beyond. I have served also as a faculty member with the Nigerian, and I have been training with them, as the faculty member in the Nigerian Institute of Chartered Arbitrators. I'm also a faculty member of Settlement House ADR Training Institute, among several others. I have been practicing alternative dispute resolution for quite a time now, from 2013 till now. Yes, so
see why I bring and come back.
yes. So that's who I am. I run a law firm called N. Nanchang & Co. It is a law firm that is into ADR as well as practice litigation where necessary. So I think basically that is about myself.
This is a barrister with many caps, and I believe that today's discussion will be quite explosive and quite informative. Sir, many people see lawyers strictly as courtroom advocates. How can lawyers position themselves as problem solvers using mediation, sir?
Well, thank you very much for that question. Now you see, basically as mediators, as lawyers, our basic training as lawyers is to litigate, to go to court and seek for solution. So what a lawyer does and what a mediator does is not different. They are all dispute resolution mechanisms. It's just that one seems to be more preferred than the other. So there are matters and issues that you have to go to court to litigate, and there are matters that you have to go for an alternative, maybe something that is more suiting for yourself. So they are both important, they are both good, but we advocate for one, especially mediation, because of the advantages that it presents. And I believe that if lawyers I know that lawyers are taught just on a peripheral basis in the law school, but when it comes to the practical aspect of it, you see a lot of lawyers who don't really understand how it works. For example, I had a situation where a lawyer was in a mediation session, and then after he listened to the party speaking, and then he had to ask the mediator, say, please sir, at what point am I supposed to cross-examine the party? So you see that he is a lawyer, but the concept of ADR or mediation is strange to him, So that is why I feel that mediation is actually a new part. It has been an old part, but it's a new part that lawyers can actually go into, and it will add flavor to their practice.
Wow. As a matter of fact, that brings me to my next question. I wanted to ask you, I said, does being a trained lawyer automatically makes one a good mediator, or are there additional skills and mindsets to have?
Well, you see, you need to understand the training of a lawyer is different from the training of a mediator. A lawyer is trained to be like someone with an eagle eye. He looks out for issues, for matters. He goes through document and sees where you've made mistakes, you made error, which he can capitalize on them. So the training you need different skills in order to operate. As a lawyer, you are trained to go to court, to advocate, to speak, in court, in open court. You argue, and the end result of that is that you want to win the matter, you want to win the case. But in mediation, it is not like that. The skills that you need in mediation is two different things. While you are looking for faults in litigation, you are looking for what you can capitalize on that will be to your own advantage, like what we call technical justice. You know that you won the case, but there is nothing that goes along with it. Technically you have won, but you may lose the relationship between the parties. The parties may not make anything meaningful out of the judgment. But as a mediator, what you do is your training, your skill sets gives you the ability to be able to listen without being judgmental. You have the ability to be able to balance and treat the parties equally, and more importantly, you help the parties to be able to come to a point where they find a solution by themselves, and at the end of it they adopt it, and there will be no need for you to go and enforce it, because you have guided them to find a solution, and they will actually make sure that they put that solution to they practicalize or do what they have agreed to do, because they are not forced into it.
That's the beauty of ADR. That's the beauty of mediation. One sweet thing about mediation is when parties come to the table and a professional mediator guides them and they come to an agreement, you see, they shake hands, they laugh, relationship is restored, and like you said, no need for enforcement, because this is absolutely their resolution.
Definitely.
I had a mediation session, just like you were saying, and the two parties came with their lawyers, and one of the lawyer was like, when we were talking, we were listening to them and we were proffering help, and the lawyer at a point interjected and said, he said, come, am I just to still sit here and I will not say something for my client? We said, no, you will say something. He said, no, not only saying something, but defend my client. I said, no.
More importantly, as a lawyer is trained to lead the conversation. He asks the question. So a situation where you see a lawyer, you just sit and just be watching what is happening without raising objections, and making his presentation and argument is a strange phenomenon. And that is why you see that it's difficult. Most times when parties come to the to court, for example, they are tensed. When your phone rings in the court, they cite you for contempt. When you enter the witness box, you are tense, no matter how educated you are. So you see the tension.
How to stand?
Yes. You can't fold your hand like this. You cannot say no. You don't do this. You don't do that. And when you do something small, they send you to prison for contempt. So you see the atmosphere is tense. But compared to mediation, when you come for a mediation session, it's like where we are now. You see, you have tea, you have water, you can't be drinking water and be conducting a court session. So you see the atmosphere is conducive, it's relaxed, people laugh, chat, say, okay, please let's take some break, and all of those things. So it gives the parties this kind of confidence to feel that, so I am involved in this thing, I am not under tension, and so forth.
Wow, interesting. Mediation is very, very quite interesting. We had some sessions where the friends who came for mediation, we knew that the tension, the atmosphere was tensed, so we got soft drinks and biscuits, and before we now told them you can take something, and they were like because they thought they came for fight, for war, and at the end of the day we had quite a good resolution. Now, do you believe that the Nigerian Bar Association, NBA, is doing enough to promote alternative dispute resolution among its members?
Well, I can say that they are doing their best, because I have attended several ADR trainings that have been organized by the Nigerian Bar Association. But you know, some lawyers are so adamant they are so addicted to the practice of litigation, such that when you bring in issues that you know, it's like a soldier, he calls the other people bloody civilians. So a lawyer is trained to go there to fight, you know, to defend his position. But when you bring someone in a situation where you want to come and learn how to just sit down and just be talking and, you know, finding, they see it as a sign of weakness. So even when you are proposing it, you know, it sounds strange. So the Nigerian Bar Association have done their best, and they are still doing, because they organize trainings under continuous professional development, and it's free for lawyers. Although I know that not every lawyer takes advantage of it, that. You know. So, but then we have also seen situation where the MBA has also accredited several ADR organizations, so that when lawyers attend their trainings, they add up their points, you know, for their continuous professional development. So MBA is doing its own part. But that is not just sufficient, because you know, when you want to go into something, you have to invest in it, you have to prepare for it. So maybe due to the expensive nature of some of the trainings, you see lawyers don't actually want to engage in it. And then you see, when you are an expert in your field and you are coming to learn from some other persons that you feel this one, where did you you know, when did you start? And then as a lawyer, you are learning another way of resolving dispute that is not in that your line. It is a strange thing, except for those who are. And we also have ADR practitioners, senior advocates, who are deeply rooted in the practice of alternative dispute resolution. So you see that they are doing their part, but it's one thing for them to do their part, and it's another thing for the lawyers themselves to embrace the training.
Wow. My people, you can actually join this conversation. You can reach us on 070 6447 5062. I take that again, 070 644 75062, or you can call us on 081 400 00989. I take that again, 081 400 00989. Call in and join us in this conversation. And I want us to also remember that at GO and AI Associate ADR Hub, we resolve disputes, we negotiate, we arbitrate, and we conciliate, so as to bring solution to our people. I think we have a caller on the line.
Good evening.
Good evening, ma'am. You are on.
Thank you. I am Deborah calling from Sabon Tasha.
Okay, Deborah. Good evening.
I want to say to Mr. Nengan, thank you for being on GO and Associates tonight.
Thank you.
And
thank you.
I understand very well what you have said, especially concerning our lawyers who are still contending or confused about the ADR practice. I hope that they get to understand the advantages ADR comes with, and they also put in their hands so that it thrives. I think I love what ADR stands for, and GO and Associates have helped us to understand that over the week, and it's beautiful. So I called in to say well done.
Thank you.
And keep it up.
Thank you very much.
Thank you, sir.
Thank you very much. We appreciate your calling in. Yes, our callers, you can also call us in on 070-878-00989. I take that again, 070-878-00989. We're having a wonderful time in the studio with our barrister here in the studio. Now, sir, what's one case that reaffirmed your belief in mediation as a powerful legal tool?
Well, there are several actually, because as an ADR advocate and as someone who teach, I forget to say that I am a teacher and I teach ADR. You know, it's something that I it's more of like a food to me. So aside from that, I have a lot of situations where ADR parties have resolved their disputes amicably. You know, I have several, but one of which, you know, one of the days I was in court, and then there is this rent matter, landlord and tenant issue. It was about to go on for hearing, and then the old man, was there to actually start up his matter, maybe start hearing and the rest of it. So when I heard the matter, I just stood up as a lawyer in the court, and I say, your honor, please, if you can give me a little time with this party, let's see if I can assist them. So the court so obliged me, and then we went outside. So the elderly man is the landlord, and he wanted someone out of his property. And then I was like, okay, daddy, can you give us some time? What is the issue? He was not ready to listen. He was bent on going on with the hearing. So I said, please just calm down. Can you tell me what is the problem? What do you want? So in just some few minutes, he was able to say what he wanted to say, and then the summary of it is that he wanted the tenant to leave his property. And lo and behold, I asked the other party, say, please, what do you want? What is the issue? You have heard what he said. He said, he is even preparing to leave the property. I say, oh, so you are preparing to leave the property? Oh, when do you think you will leave the property? And he said, on so time and so time. I say, oh, so if this is the case, then there will be no need for you to proceed. If you have agreed, let us go back to the judge, and then we inform the court that this and this and this and what you agreed upon. And we went back to the judge in chambers, and I said, oh, I have intervened as an alternative dispute resolution expert, and I'm happy to inform the court that the parties have resolved their dispute. They have all agreed. The landlord wants the tenant to leave, and the tenant is willing to leave in so time. You will pay out his outstandings, and then he will leave within so period. And the court confirmed from the parties, is that what you've agreed upon? And they said yes. And the court entered it as consent judgment and say, and warn the parties, if you fail to perform your obligation, we are going to enforce this judgment. And say, do you understand? Say yes. And that ends it. There and then, in less than 15 minutes, the matter is done and dusted. Imagine if he goes into hearing, he will call a witness, it will be cross-examined, and then they will adjourn it maybe 2 weeks, 3 weeks, 1 month after, and then you come and continue, and that matter will take close to 3 months or 4 months or 6 months before it's.
You see, that is the beauty of alternative dispute resolution. And like we often say, embrace alternative dispute resolution. It saves time. It is less expensive. It is almost free, because a lot of mediators, a lot of chartered mediators, and they do free. They do pro bonos. So, and also it preserves relationship. Now, some believe litigation is more prestigious. How can we change that perception and get more lawyers to see ADR as equally professional?
I get excited when I hear questions of this nature. I like to talk over and over these matters. So you see, gone are the days where clients will come and depend on a lawyer and say, oh, I am looking for solution. How do we go about this? How do we go about this? And you say, oh, let's file a matter to court, and then you file the matter. The CJ will assign it. Maybe it will take like 2-3 days or 1 week. By the time he assigns, before he gets to the court, he's taking another 1-2-3 weeks. And then imagine if it is a high court matter, and then you have like 21 days or 31 days, depending on 40 days, before the other lawyer will come for mention, and that after mention you adjourn again, not for hearing, for pre-trial conference. And then one party may not even be in court. And then on the day you adjourn for hearing, he will now come and file application for extension of time. And then you go back to square one. So when you look at the scenario in the court system, you discover that clients are no longer interested in all this long period of time. That is not to say that litigation has no value. There are matters that you have to go to court to be able to find solution. When it has to do with criminal matters, when it has to do with assertion of rights, you want a declaration over something. These are matters that are exclusively reserved for the court. But any other matter that the parties have the power to decide to say, oh, are forgiven, I am not going to pursue it any longer, just forget about it. Those kind of matters, anywhere they are, from the lower court to the Supreme Court, all of them, they have ADR centers, where matters of this nature can be sorted out. So when you look at litigation and mediation, clients are no longer interested in this long protracted time wasting process. They want solution, and they are looking for lawyers who can give them solutions.
Sure.
They say, I have borrowed money, for example, I have collected a loan to start up a business. I've paid the money to someone who is supposed to supply something to me, and he defaulted, and you want to go to court. When you spend 1 year in court, you are paying the interest on that loan for 1 year, and you are not doing anything. What about the process where you come, bros?
Wow.
You are supposed to supply me my goods, you did not. Are you returning my money? Say yes, I will return your money. It's just that I have 1 or 2 things. Within a short time, you have the time to discuss the matters, and the person says, please give me 2 months, I will pay you back, or I'll supply. That is the kind of solution. And you see, very soon clients will start firing their lawyers. Why do I say so? Because you see, when you see the trajectory of the courts, you see always on daily basis we have matters and issues that are coming in, they are being filed, and those matters that are filed, you don't know when they are going to conclude it. And the court system is becoming jam-packed, is congested. The judges are very tired and exhausted. They don't have assistants, and then you see no legal research officers. They stay there morning till night. From morning they resume till night, and they sit 24 hours. They sit Monday, Tuesdays, Wednesdays till Friday. They are human beings. They will get tired, they will get exhausted, so that is why you see the 21st century client is interested in solution. How can you get this thing done for me within the shortest time possible? And that is where we come in. Some of us have incorporated ADR into our practice, and then you advise. In fact, for some lawyers, they feel that, if I get these people to settle their disputes, then they are not going to pay me my fee. But we teach them. Some of them who come to our training, as I said, I am the executive director of Settlement House ADR Training Institute, and one of the trainings, as a bonus to the participants, one of the things we teach in ADR is how to charge for ADR services, and how to start up your own practice. So we teach you not just the theory and the practice, we also teach you how you are going to charge. So you can charge as a lawyer for your services, and when you charge your lawyer, it is now your duty to advise the client on the best way to get the matter resolved within the shortest time possible.
Wow. Barrister Nanchang, it's been a wonderful discussion on how time flies. So in one final sentence, what would you advise every lawyer to add as a mediation tool to his practice?
For me, I am an advocate of lawyers adding ADR as part of their practice, especially mediation, because unlike arbitration, for example, mediation is such simplified in such a way that you can create an avenue to be able to practice what you have learned as a mediator. So when you are a lawyer and you acquire the skills of mediation, it makes your services very smooth. It makes clients trust your ability, and more importantly, I want you to know that it is part and parcel of your professional responsibility as a lawyer to ensure that you explore ADR. When you look at our professional misconduct, it is professional misconduct for a lawyer to proceed to file a matter in court without actually advising his client to explore alternative dispute resolution, especially mediation. So where you see a lawyer does that is a breach of the professional conduct under section 15 sub 3D of the rules of professional conduct.
Wow. I know if I allow Barrister Nanchang, he would go on and on and on. We have had such a wonderful time, sir. Thank you for coming. Thank you for availing us your time.
Thank you.
And dear listeners out there, like we say, you can also get to us on 070 644 75062. Call us today or visit us at number 3 Kachia Road off Station Roundabout beside Polaris Bank. You'll meet us at GO and Associate Alternative Dispute Resolution ADR Hub. Remember, till next time, keep choosing peace because mediation matters. Good evening.